Next, from the Union League Club of Chicago, two leading attorneys debate the wisdom of the Supreme Court's ruling on President Obama's healthcare law. We'll hear from David Rivkin, who argued before the Supreme Court that the law was unconstitutional, and we'll hear from Professor Geoffrey Stone, the former dean of the University of Chicago's Law School, who argues the law is constitutional. This runs about 1 hour.
The very special honor, another layer in the long, close relationship of the Union League Club and the University of Chicago. It is a privilege to welcome to this podium Jeff Stone, former provost of the university and former dean of the law school at the University of Chicago, for his comments on the decision. Jeff?
Thank you, Chris. I'm delighted to be here. What I want to do is say a little bit about what this decision tells us about the Supreme Court of the United States, because I think it's very troubling. And in particular, I want to focus in this regard on the Commerce Clause issue as it was posed before the court. Now, at the time that the Affordable Care Act was enacted, there was really no serious argument that the act posed a constitutional question of any consequence. There were those who whined about it, largely on political grounds, and many who vehemently opposed it, of course, on ideological and political grounds, believed it to be bad public policy. But fundamentally, at the time the act was adopted, no one really bothered much with the question of constitutionality. It seemed to most people, to almost all people at the time, to be a relatively natural exercise of the Congress's power under the Commerce Clause of the Constitution, which gives Congress the power to regulate commerce among the states. And that clause has been used, particularly over the last 75 years, in a capacious way to allow Congress to regulate all sorts of activity in the states and the cities. The Civil Rights Act of 1964, which prohibits employers from engaging in discrimination on of race, religion, gender, and so on, was enacted based on the Commerce Clause. This seemed, given the fact that the healthcare industry is 17% of the national economy, to be a fairly straightforward application of the Commerce Clause. And indeed, at the time, if you had asked a group of lawyers or law professors and given them the relevant precedents as they existed up to the present, virtually unanimously they would have said, this is easy. Now, at some point early on, the opponents of the act, particularly a group of libertarians, came up with the so-called broccoli argument as a way of saying, wait a minute, this act goes too far. And the argument essentially was that, well, in this instance, the Congress is attempting to require people who have not yet entered the stream of commerce to do something, and that goes beyond anything that Congress previously had done or that the Supreme Court had previously upheld, and therefore exceeds the powers of Congress under the Commerce Clause. And when this argument was first made, the general response among people who have thought about the Commerce Clause was to find it basically kind of humorous. It's a bad slippery slope argument. Lawyers are very familiar with slippery slope arguments. If you do this, then the next thing you know, everybody will have to eat broccoli. And they'll have to clip their toenails twice a week. And if Congress can regulate the healthcare industry, then it can regulate anything. And if it requires you to buy health insurance, then it can require you to eat broccoli, and it can require you to do anything else that it wants you to do. And as I said, among lawyers, slippery slope arguments are very familiar. Every legal position can be addressed through a slippery slope argument. If that's true, then what else is true? And lawyers generally are pretty good at understanding there's a need to draw lines. There's a need to figure out what is the natural, legitimate extension of any particular principle, and not to carry things always to the logical extreme. And lawyers and judges are generally pretty good at doing that. And when this broccoli argument was first made, most people who are familiar with the Commerce Clause agreed with it with amusement. In a survey of people who have thought about the Commerce Clause shortly before the oral argument, over 90% rejected that position and took the view that, of course, the act is constitutional, and this is nothing but a sort of make-weight ideological excuse for trying to find a way to invalidate the statute. And indeed, even such very conservative stalwarts as Judge Lawrence Silberman on the United States Court of Appeals for the District of Columbia, former Solicitor General Charles Freed, my own colleague Richard Epstein, who believes the Commerce Clause should largely be obliterated on other grounds, basically said the broccoli argument, that goes nowhere. Now, most people who were familiar with all this were quite stunned at the oral argument by the extent to which several of the justices, particularly Scalia, Roberts, and Kennedy, embraced the argument, or seemed to embrace the argument, and take it seriously, and gave the impression that, lo and behold, they might actually take the view that this legislation was unconstitutional under the Commerce Clause, as indeed those 5 justices, including to that Alito and Thomas, so held, even though, because of Justice Roberts, the court ultimately upheld the legislation. So the question is, what does it tell us about the Supreme Court of the United States, more importantly, about these 5 justices, that they could embrace an argument and make it the law of the land that virtually everyone who's thought about the Commerce Clause, whether conservative or liberal, whether libertarian or civil libertarian, thought to be unpersuasive? Well, what it does is to reveal to us what we've seen repeatedly among those 5 justices. 2 of my colleagues, very conservative colleagues, Richard Posner and William Landis, did an analysis of the ideology of justices who've served on the Supreme Court over the past 75 years. And what they found is 5 of the 6 most conservative justices to have served on the court are currently on the Supreme Court. The other was former Chief Justice Rehnquist. So what we have is a radical group of 5 justices on the court who are far to the right of virtually anyone who has served on the Supreme Court in living memory. And that poses a problem because the majority of the court comes to be taken as the norm. And they do indeed make the law. There's no question about that. But it's a mistake not to understand how far off the mainstream of legal thought these 5 justices are, not only on this issue, but on a range of issues that have come before the court. For the most part, conservative jurisprudence casts itself as restrained, as applying law in a neutral and detached manner, and not like liberals being activists and making up the law as they go along. But in practice, what these justices have done is the exact opposite of what they and their supporters say they do. In fact, they have been extremely activist and in a highly ideological manner. So for justices who claim to be restrained, they vote to hold unconstitutional campaign finance regulation that would limit the ability of corporations and the wealthy to spend unlimited amounts in the political process. They hold unconstitutional affirmative action programs. They hold unconstitutional regulations of guns. They hold unconstitutional regulations by corporations of commercial advertising. And they hold unconstitutional the Affordable Care Act, to say nothing of Bush versus Gore. These are not restrained justices. Indeed, conservatives in this country are so confused that they attacked Chief Justice Roberts for ultimately voting to uphold this act on the ground that he was activist. Well, in fact, he was restrained. Upholding the legislation is judicial restraint, not judicial activism. So the problem we have here, illustrated by the idiosyncratic vote in this case, is a group of very conservative justices run amok, who have lost all real sense of what they say they stand for because of the temptations of judicial power. Thank you.
Well, Pleasure to be with you. Let me try to give you the other side. In fact, let me begin by pointing out that this case was not about health care at all. This case is really about individual liberty and about the way we protect it in this country. Now, lots of law professors, including Professor Stone, will tell you that individual liberty is protected by the Bill of Rights. That is only partially true. The Bill of Rights is very important, but it is the secondary line of defense in protecting individual liberty. As far as framers were concerned, the way you protect individual liberty is for structural separation of powers. Structural separation of powers means that no single unit of government is going to amass all the power in its hands. You protect liberty by diffusing power. You diffuse power horizontally among the three branches of federal government, legislative, judiciary, and the executive, something which we're very well familiar. The framers would have told you there's even a more fundamental device for protecting individual liberty, and that's vertical separation of powers, sometimes referred to as a dual sovereignty system, sometimes referred to as federalism. Vertical separation of powers to ensure that, and by the way, Justice Kennedy referred to it very movingly in his famous concurrence in the case called Lopez as the most distinctive feature of American federalism. So the vertical separation of powers, ladies and gentlemen, to be palpable, to be something more than a slogan, requires that the federal government exercises limited and enumerated powers, and the federal government and the state governments exercising the entire remaining powers, often referred to as general police powers. In order to give meaning to that proposition in turn, and I disagree with my colleague, this is not some radical invention, this is not only fundamental principle, but 220 years of jurisprudence. The court has held on dozens of occasions that to make this vertical separation of powers a reality, instead of just a slogan, a symbol, every time the federal government exercises its power under Article 1, there has to be a meaningful, judicially enforceable limiting principle that ensures that that power does not morph into general police power. A couple of other points. If you look at the totality of Commerce Clause jurisprudence, which indeed is quite capacious, has grown steadily in the last 220 years, both prior to the New Deal and before, the commerce power only works on things of all kinds, instrumentalities of commerce, commodities, products, and activities. What it does not do, it does not work on individuals, because the essence of reaching individuals as such is the essence of general police power. Now you can say to me, how is it possible, Mr. Rivkin? Federal statutes, including a bevy of criminal statutes and other Commerce Clause-based statutes, reach individuals. But they only reach individuals insofar as and to the extent that, and for so long as they're engaged in activities and partake of some goods or products. That's why the famous Commerce Clause cases, and as well as Necessary and Proper Clause cases like Wickard versus Fobert and Reich, were really not about regulating individuals. They were about regulating cannabis in the case of Reich and wheat in the case of Wickard. And the only reason Messrs. Reich and Wickard was swept into the regulatory vortex in those cases is because they had something to do either with wheat or cannabis. And to the extent they stopped being involved with those commodities, they could get out of a regulatory vortex. That is the essence of limited enumerated powers. By contrast, there's only one way to avoid general police power, ladies and gentlemen. It's to be dead. Now, we heard some jokes about broccoli, and I confess to be a person who actually coined that example. But it's not about broccoli. The problem here is from the very beginning of this case, not a single lawyer, and a very good lawyers at that, from the Department of Justice all the way up to the Solicitor General, could come up in multiple rounds of oral argument. And again, Professor Stone made us forget that we actually prevailed in both District Court and 11th Circuit. This is not something that came to the Supreme Court having lost below. But not in a single brief, in a single oral argument, much before we got to the Supreme Court, the government could articulate a meaningful, judicially enforceable limiting principle. The reason they failed to do so is because there is none. There is none. And that is all this is about. Now let me briefly, because I would like to go into back and forth, make a couple of points. Professor Stone is right. When we brought up this case, and not to be presumptuous, I was very much involved in this case. Even before the statute was passed, I was writing about the proposition I just made. When we made these arguments and the case was commenced, we were laughed at, particularly by law professors. And I think probably 98% of law professors would agree with Professor Stone. But it doesn't mean they're right. Quite frankly, it means that people who are supposed to teach the Constitution don't take it seriously. They are the ones who are looking at it from an instrumental perspective, and I'm only looking at this as a constitutional exercise. I'm not a healthcare wonk. I'm not going to give you a long peroration about uninsured and whether this law makes sense as a policy exercise. This law was a profound affront to our constitutional architecture, which is we all as Americans have to care about. This law is an affront to individual liberty. And 5 justices did find so, after in a very, very considered opinion that reaffirms the vitality of our Federalist architecture, its importance. By the way, one thing that Professor Stone did not tell us, that the other key feature of the statute, the so-called Medicaid expansion, which actually is not an expansion, but a fundamental recarving of Medicaid, a totally different program, not just relative to eligibility requirements and how many people are enrolled in Medicaid, but for the first time having states be physically responsible for the delivery of health care. That provision, which is also violative of state sovereignty, was taken down not 5-4, but 7-2, was joined by, so the 5 so-called conservative justices, and I hate this label, were joined by Justices Breyer and Kagan. So I think, if nothing else, I would hope my colleague to acknowledge with some humility that the fundamental architecture of the statute was challenged and found wanting and found to be unconstitutional by not just 5 justices, by 7. Thank you.
Sit now or stand? Sit, yeah.
All right. Well, we succeeded in getting different points of view. I don't know how that, Our theory around here is eventually we'll get this right. We'll figure out how to do this thing right. All right, who's got a question? Come on, come on. This is not, you don't have Professor Kingsfield up here.
Oh, yeah, you do.
All right, okay. So here's how this works. You stand, I hold the microphone, identify yourself, and state your brief question.
I'm Jay Schweikert, a law clerk for Judge Diane Sykes. Professor Stone, you've presented what seems, to me at least, a somewhat caricatured idea of the concept of judicial activism, which you've suggested is basically just whether you're striking down or upholding a law. And I think that probably no conservative, jurist thinks that that's the entirety of what that concept means. I think, wouldn't we normally say that it has more to do with the kinds of sources of law that you're drawing from and how you go about making a legal decision and what sort of things you take into account, rather than just the mere fact of upholding or striking something down? And if that's the case, isn't it a bit unfair to say that the mere fact that the 5 conservatives have struck down a number of laws is enough to show that they've been activist?
No. No, I obviously phrases have, whatever meanings that the general public think they have, and I think the concept of judicial activism basically means the decision to invalidate laws in circumstances where the law should be upheld. Should be upheld. And that the accusation, for example, of judicial activism that was lodged against the Warren Court was essentially that these justices should have given much greater deference to the elected branches of government than they did, and that judicial restraint meant essentially restraining the exercise of judicial power and recognizing with a greater degree of modesty and humility that the elected branch's legitimate role to play in making decisions, and that a degree of deference is essentially what judicial restraint was about. So no, I think my assumption about the definition is exactly right. It's not about whether I agree or disagree with the decision. It's not about what you draw upon. It's about whether you choose to use a muscular form of judicial review and invalidate laws that should be, in fact, upheld. And that still leaves the question of when is judicial activism, a more muscular form of judicial review, appropriate, and when is it inappropriate, which I'm happy to talk about. But I do think that the core understanding of what we mean by judicial activism, which was really crystallized in the criticism of the Warren Court, was the aggressive use of judicial power in circumstances where it may not be appropriate.
I think, just a brief point, as a sort of a philosophical matter, Professor Stone and I agree. It's been judiciary, it's not driven by whether you overturn a statute or not. It's driven by whether you do so for the proper exercise of judicial power that requires you in the constitutional review area to apply the Constitution as it exists and not rewrite it. So from that perspective, if you strike down a statute, you are not being activist. On the other hand, if you strike it down improperly, you're being activist. But let me point out one thing about patient care and Patient Protection Affordable Care Act. We actually had all justices be quite careful in protecting the product of the two political branches. Let me tell you why, in two respects. With regard to Medicaid, you heard me say that 7 justices found the Medicaid provision, as written by Congress, to be unconstitutional because it coerced the states, because it destroyed state sovereignty. And then, ladies and gentlemen, they rewrote this provision to give states a choice. So here we have a very extraordinary exercise of judicial power, because judicial power extends to construing the statutes as written. You can construe them in a variety of ways on the doctrine of constitutional avoidance. You can stretch it even fairly far to avoid overturning it, but it doesn't include rewriting it. So we have 7 justices willing to rewrite the statute to Medicaid, and then we had 5 justices, including the Chief Justice, that rewrote the individual mandate to make it supportable by the taxing power. So I hope my colleague agrees with me, but this is one exceptional decision. Well, he doesn't like the Commerce Clause portion of it, or Necessary and Proper Clause, that as far as judicial deference is concerned, I've never seen a case, certainly in modern history, where the court has twice rewritten, to be candid, the 2 key provisions of a statute to save them from invalidation.
Well, 2 points. I mean, first, the fact that the court invalidated the Medicaid provision was not the subject of my remarks. My remarks were about the Commerce Clause issue. The statute posed a whole variety of legal challenges, and I was focused on the one which was regarded as central to the constitutionality of legislation from the beginning, and which was the one where the court's decision, I think, was seen as most controversial. The fact that the Medicaid provision was held unconstitutional is or is not problematic, but it's not the central point of my remarks. And I think actually the court's decision on that issue was a more reasonable one. I'm sorry, what was the second thing you said?
Well, the second thing I said, at least the 4 justices that you call more and the Chief Justice rewrote the individual mandate to make it supportable and the taxing power.
Courts do this all the time. I mean, courts routinely interpret legislation to save their constitutionality. That's one of their responsibilities.
But not rewrite it, well.
You say rewrite it, I say interpret it, they say interpret it. But they interpreted it, and they interpreted it in a way to save its constitutionality. Courts do this all the time. That's part of judicial restraint. Part of judicial restraint is to not gratuitously invalidate laws, not to invalidate laws if there is a reasonable way of saving the constitutionality of the law. And that's all they did by what you're referring to as rewriting.
Hi, my name is Kay Pick. I'm a lawyer. And I have a question about the decision as it relates to Medicaid, which Mr. Rivkin may have answered in part. And the question is whether what the decision did is technically leave Medicaid expansion in place with the exception of the most severe penalty that the federal government can impose, which is to not fund Medicaid at all if a state refuses to expand the Medicaid that it has. And so the question is, if technically the decision did leave Medicaid in effect and made it mandatory for the states, except for the penalty provision, may the federal government impose yet some other kind of a penalty other than taking away Medicaid funding entirely? So that's the question.
Let me try to answer it this way. By the way, the Medicaid provision was something we challenged from the very beginning, and while it did not get the extent of notoriety that the challenge the individual mandate had, this is a core provision of a statute. In fact, I'm sure Professor Stone would agree, the individual mandate was meant to drive up the demand for insurance coverage, and Medicaid was one of the primary supply-side solutions to it. There's a wonderful symmetry here. Now, what the court has done here is quite remarkable, and I very much like this part of my opinion. Hate to throw names, but there are enough lawyers here, you'll forgive me. While the court, going back to the Spencer versus Davis case of 1937 in South Dakota v. Dole, articulated the proposition that it is possible to use spending power in a way that is sufficiently coercive, again, to deform state sovereignty and impede this constitutional framework of dual sovereignty. They never found it to be the case. This is the first time the court has actually said this is enough. The reason for it, again, to explain briefly, this was a fundamental recarving of Medicaid. This was not just, as I said, expansion of eligibility. The state's on the hook now for possibly providing services by requiring them to ensure the sufficient density of a network. I hate to get technical. Plus the new Medicaid, a number of states felt, including the states I represented, was unsustainable and would drive eventually to bankruptcy. And those of us who are watching what's happening in Europe now, I can tell you probably would not disagree. Greece is sovereign only in name. Pauperizing a sovereign is a sure way of destroying sovereignty as coercion and conscription a la Prince in New York. So that's the big framework of the decision relative to what the states can expect the federal government to do now. So the states have a choice now. They can either continue with Medicaid as it was and not suffer the loss of any funds that went with the old Medicaid, or they can opt into the recarved Medicaid and get more funds. That's at least a clear holding. But the decision also very much left open the possibility that the federal government would not be able to penalize states by withholding large amounts of money, both in the Medicaid program and other so-called cooperative federalism program. How much is enough, I don't know. The decision does not make it clear. But there are other aspects of even old Medicaid where potentially states were on the hook to lose money. The so-called maintenance of effort. Again, I don't know if you practice in this area. So it really opens up a possibility that the federal government would not be able to have as much of a club vis-a-vis the states. And very briefly, let me close by saying this. What does it tell us? Because there are some, again, fairly unkind remarks during the argument about how can you coerce the state by giving them a lot of money? Well, if you give a state a lot of money over a period of years, and the state becomes dependent upon that, and its public health system would collapse if you draw the money precipitously, the only way that's consistent with the respect for the sovereignty of both players is you cannot have a sudden precipitous change. Federal government can change the funding, but it would have to do it over a period of years. And again, the logical way to think about it, if you think about two sovereigns in the international sphere, you have a mutual defense treaty. You can terminate the treaty, but most treaties have reasonable termination periods. You cannot abruptly withdraw the protection. Federal government cannot abruptly withdraw the funding or dramatically change the nature of the effort. But there will be new cases litigated in this area for years to come because, again, for the first time, the court has said, you cannot do this, Congress. The first time a spending power exercise has been found unconstitutional since Stewart machine case.
So, do I understand your
This is a follow-up, which is going to be really brief.
Very brief. Do I understand your answer to mean that the expansion is mandatory?
No, it's not.
So you're saying it is not mandatory, but you're saying that if a state doesn't adopt the expansion, the federal government can gradually withhold funds over a period of time from the states under their Medicaid program?
No, but the technical holding is that you have to give the states whatever funds you've given for the old Medicaid. I was taking it to the next level to say implications of his decision is that the federal government cannot precipitously change the level of funding, large big ticket items, because that would be unduly disruptive and produces a kind of calamity that you cannot impose on another sovereign.
Jeff?
Yeah, I basically agree with much that David said, but I want to make a point again about consistency on the part of justices across different issues. So on this issue of coercion, here's another case that came up to the court several years ago, in which the same justices that voted that this coercion of taking away money in the Affordable Care Act context was unconstitutional, rejected the same argument. So until fairly recently, most law schools in the United States refused to allow the military access to the law school's recruiting facilities for purposes of recruiting law students because the law schools had general policy that no employer could use their facilities if the employer discriminated on the basis of race, religion, gender, ethnicity, sexual orientation. And the military discriminated on the basis of sexual orientation, and they therefore excluded the military. Members of Congress didn't like this, and they therefore passed the Solomon Amendment, which essentially said that if any part of a university fails to give equal access to the military, then the entire university will lose all federal funding. And this was challenged on the ground that it was unconstitutional, because it was obviously wildly coercive about the liberty of the individual universities and law schools to do this very specific, narrow thing by using this enormous cudgel, which would basically put any university out of business. And the Supreme Court, the same justices said, no problem. This is perfectly okay. So again, it's this question of, what's driving these justices in these cases?
Can I tell you why in one sentence? Because what my colleague is talking about was a matter of disposing of the Bill of Rights. I'm talking about structural separation of powers. The last time I checked, universities were not sovereign entities, states are. It's very simple.
Okay, next question.
Hi, my name is Michael Lacara. I'm an accountant, so not an attorney. The individual mandate now being classified as a tax, and taxes traditionally have been more or less assessed on transactions or income from whatever source derived, et cetera, or transactions. Estates, so on and so forth, monetary movements. The individual mandate now being a tax, I guess my question is if Congress has the authority to tax on action or inactions, are there any constitutional limits with respect to taxing powers, and in particular in coercing the individuals to take some form of action?
Right. Please, well, as you might have surmised, that's my least favorite part of an opinion. What the Supreme Court has done is decisively taken off the table the Commerce Clause that both Professor Stone and I talked about, as well as the necessary and proper clause, and articulated again very vigorously the notion of limited enumerated powers. Now, of course, all powers have to be limited enumerated. Of course, it's also the case that various enumerated powers do not have the same limiting principle. What the decision has done basically, and by the way, I said rewritten, we can disagree about that, but frankly, that's not the most important part. It's a one-off. You cannot cite this case for a proposition that's okay to write statutes because ostensibly that's not what it says. The real problem in this case, it has destroyed the limiting principles associated with the use of taxing power. It's done in a couple of ways. It has basically destroyed the distinction between a penalty and a tax. And the problem was, by the way, talking about rewriting, the problem is that the statute had, I hate to get technical, not only Section 5000A, that was the penalty, it had an independent mandate. So that portion of the statute got written out of existence. What's also interesting, if you look at the way the statute was passed and scored by Congressional Budget Office, Congressional Budget Office assumed, ladies and gentlemen, that there will be massive compliance because Americans are law-abiding, compliant people. One of the things that this decision has done, actually, and it's worth writing about, is by transforming it from a mandate. And by the way, we argued about it in the very first oral argument I had. One of the questions was sparring with DOJ is whether or not if there was no penalty, this mandate was real. And I hope Professor Stone would agree with me. In our legal system, if a government imposes a mandate using the word shall on you with no penalty, you should still do it. it still is the right thing to do. And for people in professions like accounting, doctors, and lawyers, not complying with requirements, even not backed by a penalty, is something which you can be punished. And you remember all the morals clauses in contracts with athletes and Hollywood types. So the court has done that. I could not resist pointing this out, but basically it eviscerated the distinction of a penalty and a tax. And second, it's done something else that's even worse in my opinion. One of the key limiting principles for taxes was for direct taxes that framers believed to be more pernicious. So framers believed that they would have indirect taxes, which taxes on transactions and things, guns, tea, coffee, carriages, and direct taxes. And direct taxes are taxes on individuals. These framers disfavored both because they frankly didn't want the government to have too much money, Reagan's type starving the beast, but also because direct taxes operate on individuals because they exist. So very capable of morphing the general police power. Apportionment, Chris Stone and I can spend hours talking about what apportionment means, and only twice in our history we've done that. But apportionment was meant to make it very difficult. What the Chief Justice sadly done, he basically redefined apportionment out of existence because in his thinking now, there's no such thing as direct taxes. All taxes now are indirect. So in theory, you can have a situation where we now cannot have Congress mandate broccoli purchases under the Commerce Clause, but it can penalize you for not purchasing broccoli and cars and infinite variety of other things. Now, in Chief Justice's defense, I'm sure what he's thinking about is taxes. The T word is important, and congressional ability to exercise that power is far more limited than the Commerce Clause. I hope he is right, but let the record show that's not a judicially enforceable, meaningful limiting principles. It kind of Garcia-sizes this whole exercise. But I hope that answers your question.
I think that's basically right. I found the tax part of the opinion the most, quite difficult. I don't think that's the way the act was created, and I do think in terms of, I wouldn't use the word rewriting, but I think that Roberts' attention to that was peculiar. I would have much rather have seen the court uphold it on Commerce Clause grounds, which I think would have been much more straightforward, much more conventional under existing law. I think that the characterizing it as a tax opens up a can of worms that I don't really understand the implications of, and I don't think anybody does.
Good morning. Peter Scosi. I have a question. I want to continue on the theme of the Medicaid and coercive spending issue and flip it to the issue of transportation. Federal government has proven they can withhold money to states that don't raise their drinking age, but perhaps they're able to do that because it's only 3 to 5% of total federal highway spending. Of course, most of the transportation spending that takes place in states, about 80% of it comes from the federal government, so it is a large chunk of money. Moving forward, there is an interest afoot in Congress and amongst national groups to require or to apply national goals and objectives to our transportation spending so that our transportation dollars grow the economy, improve the environment, provide better access to jobs, things like that. Will those kinds of coercions or provisions to future funding be affected by this decision?
Well, very excellent question. Very briefly, first of all, we had the good fortune of being able to argue, again, very early on. I remember arguing before Judge Vinson that whatever dividing line between coercion and non-coercion might be, and we know from the teaching of South Dakota that 5% is not enough. What was it, 20? Here, the stakes were so huge that it was absolutely clear. The states, again, had a choice, a Hobbesian choice between embarking on this path that they felt would pauperize them or losing billions of dollars and having a collapse of their public health. So Hobbesian level of consequences on both sides. If we have another case where what's at stake is 30% or 40% of some funding that occupies a big space in the state budget, would that be enough? I don't know, but it would be a very palpable question as part of his decision. If I were drafting a new statute, my advice to the federal government would be do not wield your cudgel all or nothing. So attach strings to specific pots of money. So you don't do it this way, you lose 5%. You don't do it that way, you lose another 5%. Don't say if you don't do it my way, it's the highway, no pun intended.
Nice. So this is another illustration, by the way, of the slippery slope problem, right? So if one took the approach to the Medicaid issue that the court takes to the Commerce Clause issue in terms of the fear of opening up a door to something, then given the position the court takes here about Medicaid, presumably the court would say, well, wait a minute, that means that the federal government can never withdraw funds from a state because it might open the door to what happened in this case, right? And therefore, instead of trying to deal with this case when it arises, right, which is what most of the time we do in the law, we wait till we get the case that actually poses the problem, the same logic that the justices used in the Commerce Clause argument on the broccoli point would be to say, okay, well, given the fact that if we open the door to the government withdrawing benefits, if states don't do what we want them to do, that could lead to this Medicaid situation, then we should never let the federal government condition grants to the states. Nobody's made that argument. So it's just again, another point about consistency here. If one's going to take the slippery slope argument seriously in one case, one should take it seriously in the other, and presumably that would mean that the principle the court should have announced was that the federal government can never condition grants to the states, which makes no sense, of course, which is what I would say is the same thing about the broccoli case.
We're not arguing that, of course, but I hope you would agree that there have to be limits, because again, if you take the vertical separation of powers seriously, you cannot possibly tell the states, well, we're going to pauperize you immediately, or we're going to take you down to a Hobbesian level of collapse of law and order. We're not talking about small, I mean, again, what worked for us is the very palpable, remember making this point during the summary judgment argument. This is very simple. It's not like we're going to cut off some funding for technology incubator or state university. So there have to be limits.
Right. No, I agree completely there have to be limits. My point is the opposite. It's that we deal with the need for limits by finding the case when it arises where we need a limit. And when that case arises, we act on it. And if one took that same approach to the Commerce issue in the case, one would have said, okay, well, this is an instance where you've got a huge impact of health care on the national economy, where the decision of individuals not to buy health insurance has substantial effects on both the healthcare industry, on interstate commerce, and on other individuals who are forced to pay higher premiums. And it may be that for the federal government to require individuals to do something because it may down the road have some effect on interstate commerce is so attenuated that you'd hold that unconstitutional when that case arises. But that the right way of dealing with that issue in the Commerce Clause context is to wait till that case arises, not to draw the line at the very first hypothetical or the very first case. That's my point.
Okay.
Hi, my name is Jan Goldberg. I'm a retired teacher of American politics and government, advanced placement level at the high school level. And my question is for Mr. Rivkin, something you said earlier about the Commerce Clause. You said, and I quote, Commerce Clause only works on things and activities. So is not healthcare an activity? And just a second part to the question, if I participate in health, and Mr. Stone just said in his last answer, my premiums would be higher because of people that don't participate or can't participate, is that not an affront to my liberty? And is not the federal government, as Mr. Roberts said, an umpire of people whose liberty has been abridged?
A couple of things, save best to last. Yes, I mean, the things and activities, again, was sort of a paradigm we evolved and refined in the case. But apropos of your example, the federal government has most capacious power to regulate all aspects of insurance and all aspects of consumption of health care. For example, and again, I remember being asked this question by the district court judge, who was excellent, very early on. Mr. Rivkin, do you agree that the federal government could pass a law which would say that you could not consume health care in this country unless you had an insurance card? So you cannot pay for it with cash, specie, barter, whatever. And I said, leaving aside the Bill of Rights issues, because there's, the privacy cases and bodily autonomy, as a structural separation of powers, it would be absolutely true. But that's not what the government has tried to do. The government has tried to get at it by regulating individuals because they exist. And that's an exercise of general police power. Now, my able counterpart from the Justice Department kept talking about that it's too pedantic and it's formalistic, and we kept talking about the fact that in structural separation of powers, process and being pedantic and formalistic means all. But to be more responsive to your question, let me point out this. Yes, we all agree that inactive individuals, individuals who don't consume a particular good and service, indeed impact as an economic matter on those who do. It's called externalities. The problem with this argument is that, I repeat, it has no meaningful limiting principles, because with all due respect, Professor Stone, the government has pressed with great vigor the argument of uniqueness of healthcare, talking about the cost shifting and this and that and how healthcare is different, and they utterly failed to persuade the courts that that is right, because there's nothing unique about, for example, the famous or infamous cost shifting, because, ladies and gentlemen, in every sphere of economy where you don't pay cash on the barrel, there's cost shifting. I even had numbers, I've sort of forgotten them by now. There's $43 billion worth of cost shifting in healthcare. There's $28 billion worth of cost shifting in credit cards. When Americans unfortunately welsh in their credit card bills, what do you think happens? It gets cost shifted to those who don't. And there was $1 trillion worth of cost shifting in the mortgage business. So every time you don't make people pay cash on the barrel, there's cost shifting. And every time you don't buy a car, that has impact on cars. And every time you don't buy broccoli. So there's nothing unique about healthcare. And the other argument the government made is the possibility of catastrophic impact. Well, you know, I actually, perhaps it was a little flippant. You remember the Aflac commercial? Aflac tells you that you need, it's not enough if you lose your job to have medical coverage. You have to worry about groceries and paying for the roof over your head. So Aflac is telling this to you. There are all sorts of situations where you can have a catastrophic, unexpected result. The healthcare is not unique. The government tried it for 2.5 years. It's not unique in a meaningful legal sense. Otherwise, everything in life is unique. Everybody uses hydration and nutrition on a regular basis, or you're going to die. Everybody uses some form of transportation. Everybody uses many things on a regular basis. Inevitability of consumption is not, if you're going to use an inevitability of consumption argument, it becomes nothing more than a facsimile for your existence. You regulate people when and only when they start doing things and activities, not before. Well, and we spent a long time
the decision not to have health care is doing something. You can't characterize that as not an activity. It is an activity. It's totally artificial to say that doing something is doing something, but the decision not to do something is not doing something. They're both doing something.
But Professor Stone, under that logic, what is the limiting principle? Decision not to buy the car.
Substantial impact on interstate commerce, just as the law has been for the last 70 years.
But everything in the aggregate has substantial impact on interstate commerce. I can think of no inactivity that in the aggregate would not have a substantial impact on the interstate commerce. There's no limiting principle.
With all due respect, my decision not to eat broccoli does not have a substantial impact on interstate commerce.
Your individual decision does not, but an aggregate decision of many people not to eat broccoli. And by the way, one other example which you'll find, I think, palpable, we argued strenuously that the numerous forms of non-consumption in the aggregate have far greater impact on not bending the cost curve. Remember, one of the things about PPACA was not just extending coverage, bending the cost curve. Again, I'm not a healthcare policy wonk, but if you don't eat healthy food, and if you don't exercise, and if you don't do such basic things as going to a doctor for a checkup, you are going to be a disproportionate consumer of health services who are largely going to be subsidized by society. So under that logic, you can impose an infinite variety of wellness mandates on people. It would be quite reasonable. As a matter of fact, there's a better connection between that than lack of insurance. So there's no limiting principle. I'm sorry. There just isn't one.
Next question.
Preston Knoll, Tradition, Family, and Property. Let's get to brass tacks. When can we get as Catholics and as Americans our religious liberty back? It's being stolen from us by the U.S. Supreme Court, by Barack Obama's administration, by Kathleen Sebelius and their cohorts, and they're going to try and force us and other Americans who may disagree with us to fund and pay for services that we are unalterably opposed to on conscience provisions. When will we get our freedom back? I feel like I'm a slave now. When does it come back?
I'll let you tackle that.
Somewhat off the point, but maybe when the federal government stops giving money to the Catholic Church.
We have not dealt with those issues in part because there are some serious standing problems with having states try to vindicate religious liberty because, of course, anti-establishment clause, it's not obvious that states have any opportunity to do that. But I mean, I would say this, I'm not involved in this case, but the case has been brought by a number of religious institutions, and there are certainly good reasons to believe that the mandate, and you're talking presumably about the mandate to purchase contraception, may all go down, so stay tuned.
Can I add a word to that, again, about consistency? Until 25 years ago, the Supreme Court doctrine would have made this a very serious constitutional issue. Can the federal government, can the government, state government, can any government, require individuals or prohibit individuals who have certain religious beliefs from acting in ways that are inconsistent with their religious faith? And even though the law is not directed at them, so a law that said Jews can't do something or Catholics can't do something would always be deemed unconstitutional. But the framework of a law like this is one that says that no one may do something or everyone may do something, and that thing has particular religious implications to individual faiths. And in the past, the court would have said, well, we have to look at how significant the impact upon a religious group is and whether the state has sufficient justification to impose that. And I suspect that under that law that previously existed, the court would well have invalidated the current law that you're opposed to. But it was Justice Scalia who wrote an opinion overruling all of those prior decisions in which he said, no, when a law is neutral on its face and is not directed against any particular religious group, then there's no discrimination on the basis of religion, and religions have no constitutional right to an exemption from a law of otherwise general application. That's the law today. And that's the law produced by a group of very conservative justices. And of course, they did it in the case involving a Native American group which wanted to use peyote. And instead of saying, which they might have said, that the state interest in prohibiting this group from using peyote in their religious rituals involves a compelling governmental interest and therefore you can prohibit them from doing this, Scalia's opinion said, no exemptions from laws of general application. So the problem you've got is, under the existing law, there's no argument. It's a bad law. I think the current state of the constitutional law is bad. But that's what you've got, thanks to Justice Scalia.
Let the record show that we're largely in accord on this issue. I happen to think, though, that the reason this particular mandate, the HHS mandate, would go down is because of something called RFRA, Religious Freedom Restoration Act. That was a congressional reaction. Right. Yeah, and the fact that, of course, the Obama administration is going to argue that the PPACA somehow supplanted RFRA, but there's no language in there that says so, and RFRA itself is very clear that there has to be an explicit waiver of RFRA requirements. So, but as to the constitutional framework, yeah, it's tough.
Bob Fitzgerald, retired. I'd be interested in your reaction and thoughts on the vote of Justice Kennedy.
Well, I mean, Justice Kennedy is clearly in the middle of this court. That does not make him a moderate. As Justice Stevens, Justice O'Connor, Justice Powell all pointed out, Justice Souter, during the course of their tenures, the court has moved further and further and further to the right over the course of the last 30 years. And Justice Kennedy is in the middle of this court. And what that means is that whereas the other 8 justices tend to have, not an unvarying view, but they tend to have a theory or an approach to constitutional law that makes their positions often fairly predictable on the issues that are seen as difficult, which is why the court takes them. Justice Kennedy is not so predictable. So what does that tell us about Justice Kennedy in this case? It tells us in this case that he's inclined to believe in a more modest congressional power with respect to the health care law. And I don't think it can tell us much more than that. On other issues, like same-sex marriage, I expect Justice Kennedy will be more aligned with the more liberal justices. So he's the wild card on the court. Justice Scalia once said to me with respect to Justice Kennedy, Scalia and I were colleagues at the University of Chicago Law School for a number of years. He said to me one time that I'm no Justice Kennedy. I don't walk around the halls of the court wringing my hands saying, oh me, oh my, what am I going to do? The fate of the nation is in my hands. I have to figure out what the right thing is to do. You know, that's Justice Kennedy.
Can I defend the Justice Kennedy's honor a little bit?
I wasn't attacking his honor.
No, you and I are largely in accord, but just to add to that, I actually felt, and one of the reasons, again, not to toot our own horn, I was enormously optimistic from the very beginning, is because we've studied Justice Kennedy's jurisprudence, and while on many issues, indeed, he provides that swing vote that Professor Stone mentioned, there's one area of the law, one area of jurisprudence where he has the most articulate voice in the court, particularly with the departure of late Chief Justice Rehnquist and retirement of Justice O'Connor. He is the most committed Federalist and the person most committed to dual sovereignty system. You cannot fail to notice that if you read his famous concurrence in Reich, concurrence in Lopez, excuse me, his language in the Bond case from the previous term. He actually believes it. He is the one, in my brief opening remarks I mentioned, the most distinctive feature of American constitutionalism. It's actually from his concurrence in Lopez. He gets it. I believe, despite all statements to the contrary by both my practicing lawyer peers and law professors, Justice Kennedy will not be a problem because he could not vote any other way on this without repudiating 2 decades worth of work, and I was right. He actually gets this one.
You're watching the Illinois Channel, an independent nonprofit corporation formed to provide gavel-to-gavel coverage of Illinois state government and other public affairs events taking place across Illinois.